as far as infringement is concerned, there are 3 or 4 aspects of infringement which have immediate bearing or relevance as far as the patentee is concerned. Point number 1, the moment the patentee comes to be aware of or has been notified of the infringing activity, what is the remedy that is available to him, which is the forum that he can appear before or he can approach to seek a redressal of his grievance, what kind of reliefs are available to him, how does he establish jurisdiction, so on and so forth. The first thing that needs to be understood is, unlike the Trademark Act and or the Copyright Act, the Patents Act does not contain a special jurisdiction clause which bestows a right on the patentee to institute a suit for infringement at a place of his business or where he resides. Therefore, he is left to fit his case or establish his case within the Code of Civil Procedure, which otherwise governs the conduct of civil suits in this country. Therefore, the patentee will have to establish that he has either a cause of action at a particular place, or he has to institute the suit at the defendant's place of business or where the defendant resides. Simply put, the patentee has to establish jurisdiction on the basis of section 20 of the CPC. Now, this actually is something that could form a potential constitutional ground, because there is no apparent reason why a patentee or patent owners in general have not been bestowed the same kind of special jurisdiction clauses, have not been bestowed with such special jurisdiction clauses which are otherwise available to copyright owners and trademark owners. If the idea is to extend a benefit such as this to small authors or authors in general, so that they may be in a position to take action against an infringing party at a place of their convenience, surely this is a benefit or a relief that can also be extended to patentees, because at the end of the day, patents need not be owned by large corporations, they may be owned by individuals or small entities. Therefore, this is one thing that seems to be amenable to a writ challenge or a constitutional challenge at some point in the future. It is surprising that this has not been agitated in the court, considering that this anomaly has been existing in these legislations for quite some time, at least for the last 5 or 6 years. As far as reliefs in a suit for infringement are concerned, reliefs are governed by section 108, and these are typical reliefs, which is an injunctive relief, relief of damages, or rendition of accounts, delivery up, seizure and destruction of infringing goods. Now, section 104 of the Patents Act spells out the forum that he may appear, and it actually goes on to say that a patentee cannot approach a court which is lower than the district court to institute a suit for infringement. Now, section 104 has 2 aspects to it. It first of all spells out the court or the forum that a patentee is entitled to approach to institute a suit for infringement. It also contains a proviso which goes on to state that the defendant in a suit for infringement, if he chooses to challenge the validity of a patent by way of a counterclaim under section 64, then both the suit and the counterclaim for revocation would be transferred to the appropriate high court for consolidated adjudication by the high court. Now, this is a feature that has a historical basis, and there seems to be a policy call behind this, and for this one has to refer to the Iyengar committee report, which went on to state that whenever there is a challenge to the validity of a patent by way of a counterclaim or a revocation petition, it will be the appropriate high court which shall be seized of the matter, which is why this particular provision continues to be in force despite the constitution of the Intellectual Property Appellate Board. Now, since we have already touched the issue of counterclaim, I will have to refer to certain aspects of the defendant's rights. Whenever the defendant or a defendant is sued for infringement, there are 3 or 4 options that he may mix and match, so to speak, depending upon the objectives that he wants to achieve. So, for instance, it is possible for the defendant who has probably received a notice for infringement to file revocation petitions before the Intellectual Property Appellate Board or post-grant opposition under section 25(2) if he is within the requisite time period, which is a period of 1 year from the date of publication of the grant of the patent, as a preemptive action to challenge the validity of the patent before the patentee has the opportunity to institute a suit for infringement. Now, what this does is it creates a certain cloud on the title of the patentee or the validity of the patent, and in a way it helps the defendant prevent the grant of any ex parte orders or interim reliefs pending the disposal of the revocation petitions before the Intellectual Property Appellate Board. In the alternative, it is also possible for the defendant to file revocation petitions subsequent to the institution of the suit for infringement and raise the revocation petition as a defense under section 107 before the court which is seized with the suit for infringement. In the alternative, it is also possible for the defendant to institute counterclaims as a counterblast to the suit for infringement, so that the court which is seized with the aspect of infringement is also seized with the aspect of validity. Now, from these options, what comes out or what follows is that the framework is such that there is a possibility for bifurcated litigation, which means there could be instances where one forum is seized of the issue of validity of the patent, which is the IPAB, and another forum is seized with the issue of infringement of the patent, which could be a district court or a high court, as the case may be. Now, in a situation such as this, one would have expected the framework of the Patents Act to provide for a certain provision which envisages the sequence of events in terms of which of these actions will proceed first and which of these fora will have to hold its hands, so to speak, until the other forum is done with its adjudication. For instance, if there is a pending challenge against a patent before the Intellectual Property Appellate Board, one would have expected the legislature to provide something on the lines of a section 124 of the Trademarks Act in the Patents Act. Section 124 of the Trademarks Act provides for stay of the suit proceedings before a court when there is a rectification petition challenging the registration of a trademark before the Intellectual Property Appellate Board. Now, what this does is to ensure that the court does not proceed to enforce the patent only to realize at a subsequent stage that it has actually enforced an invalid patent, which would have actually caused irreparable harm to the defendant or considerable harm to the defendant, even if it is not irreparable. Although the absence of section 124 in Patents Act seems to suggest that such a provision was never intended by the legislature while it was intended for the Trademarks Act, it could always be argued that a court has the inherent power to not enforce a patent on the ground that there is an outstanding challenge to the validity of the patent, and in light of that outstanding challenge, it ought to err on the side of caution to not enforce the patent until there is an outcome one way or the other in the revocation proceeding or the invalidation proceeding before the Intellectual Property Appellate Board. What also needs to be understood is that there could be instances, and these instances happen with such frequency, where the defendant merely files a revocation petition before the Intellectual Property Appellate Board merely to create a doubt over the validity of a patent and to prevent the grant of an ex parte injunction, when the fact of the matter is the revocation petition may not have any merit whatsoever. Now, the option in such a situation before the court, which is seized of the issue of infringement, could be this. The court could look into the credibility of the revocation petition before the Intellectual Property Appellate Board, take a prima facie view of the same, and then decide whether or not the revocation petition is strong enough to prevent the grant of an interim injunction, or is it so frivolous that it does not merit looking into and that it does not warrant refusing the grant of an interim injunction. Now, this is, I think, a much more balanced way of handling a situation such as this, because then the court has had an occasion to apply its mind at least on a prima facie level to the invalidation challenge, and then doing justice to the matter, as opposed to simply treating a mechanical filing of a revocation petition as the be all and end all of the matter of the grant of an interim injunction.